Now let's turn to the court's cases involving sentencing. Here, defendants did quite a bit better. Let's begin with a basic reminder about why we incarcerate felons in the federal system. Prison is for punishment, not rehabilitation. So says Section 3582A of Title 18, which instructs sentencing courts to, quote, recognize that imprisonment is not an appropriate means of promoting correction and rehabilitation, close quote. In Tapia v. United States, the Ninth Circuit held that while a court cannot impose a prison term to assist in rehabilitation, once imprisonment has been chosen, the court may consider the defendant's rehabilitation needs in setting the sentence's length. Under this approach, the Ninth Circuit affirmed a 51-month prison term so that the defendant could qualify for and complete the Bureau of Prisons' residential drug abuse program. Nice try, Ninth Circuit, but the Supreme Court unanimously reversed based on the plain meaning of the statute. While a district court at sentencing may discuss the opportunities for rehabilitation within prison or the benefits of specific treatment or training programs, it may not actually choose imprisonment or, once chosen, lengthen a sentence for the purpose of fostering rehabilitation. Prison is for punishment, and even though you may be well-meaning, a court shouldn't lengthen someone's term to assist in rehabilitation. The defendant also won in Pepper v. United States, where the court held that a district judge resentencing a defendant after a remand from an appeal has the discretion to reduce his sentence based upon evidence of the defendant's post-sentencing rehabilitation. The Eighth Circuit Court of Appeals had held that the district court did not have any discretion at resentencing to consider any evidence of circumstances that arose after his initial sentencing. In the Eighth Circuit's view, considering that new evidence at resentencing would create unwarranted sentencing disparities and inject blatant inequities into the sentencing process. The court was particularly concerned that the exercise of the district court's discretion would be inconsistent with the sentencing guidelines. The Supreme Court reversed. In 1970, Congress codified the long-standing principle that no limitation shall be placed on the information concerning the background, character, and conduct of a person convicted of an offense, which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. That's Section 3661 of Title 18. And when the court in 2005 issued its seminal decision in United States v. Booker, which had the consequence of making the sentencing guidelines only advisory, any legal obstacle to the district court considering evidence of circumstances that arose after the initial sentencing evaporated. The decision was great news for the defendant in the case. He had completely turned his life around while the appeal was pending. And instead of being resentenced to prison, his sentence was reduced to 2 years, which he had already served, and he was released as a free man. The court considered 2 cases this term dealing with the impact of state convictions and sentences on federal sentencing enhancements. The lower courts are filled with these cases now, where federal sentencing enhancements depend on how state criminal convictions and sentences are interpreted by federal courts. It is a complex area of law because federal and state criminal codes and sentencing policies don't always match up very well. Our first case is McNeil v. United States, where the Supreme Court faced a question of timing. Under the Armed Career Criminal Act, a prior state drug trafficking conviction is considered to be a serious drug offense if a maximum term of imprisonment of 10 years or more is prescribed by law for the offense. At the time the defendant was convicted, state law prescribed a term of imprisonment for cocaine trafficking of 10 years. State law was subsequently amended so that the maximum term of imprisonment for drug trafficking was only 38 months. The issue for the Supreme Court was whether to apply state sentencing law as of the time of the state conviction or as of the time of the federal sentencing. Section 924E1 provides that its sentencing enhancements apply to individuals who have 3 previous convictions for a violent felony or a serious drug offense. The court unanimously held that the plain meaning of the statute, particularly the use of the phrase previous convictions, required use of the law at the time of the previous conviction. Personally, I'm not sure just how plain that meaning is, But the result convinced all 9 members of the court, so at least we have a plain result, if not a plain meaning. Next, we have a case involving the question of whether a particular conviction under state law constitutes a violent felony under federal law. Here's where the mismatch between federal and state criminal laws create lots of legal issues and lots of room for error. In Sykes v. United States, the Supreme Court had to decide whether a conviction under Indiana law for felony vehicle flight, which is defined as knowingly or intentionally fleeing from a law enforcement officer in a vehicle, constitutes a violent felony under the federal sentencing enhancement statute in the Armed Career Criminal Act. If the enhancement did not apply, the defendant would serve a 10-year sentence. The enhancement, if applicable, added an additional 5 years. It was clear that the fact patterns technically constituting a violation of Indiana's law were extraordinarily divergent, ranging from simply not pulling over quickly enough in response to a police vehicle's red lights to a high-speed, dangerous chase. Yet under the federal enhancement statute, the court needed to make a categorical decision, looking only to the fact of the conviction and the statutory definition of the prior offense. The phrase violent felony is defined in Section 924 of Title 18 as an offense punishable by more than 1 year of imprisonment that 1. has as an element the use, attempted use, or threatened use of physical force against the person of another, or 2. is burglary, arson, or extortion, involves use of explosives, or otherwise involves conduct that presents a serious potential risk of physical injury to another. The Supreme Court held in a 6-3 decision, with a majority opinion by Justice Kennedy, that felony vehicle flight, as defined in Indiana, did indeed constitute a violent felony. The court reached that conclusion by noting that when a perpetrator defies a law enforcement command by fleeing in a car, the determination to elude capture makes a lack of concern for the safety of property and persons of pedestrians and other drivers an inherent part of the offense. In other words, anyone who would flee from police in a vehicle is a danger to others. Next, we deal with the issue of minimum sentences for those criminals who use, carry, brandish, or discharge guns in the course of committing any crime of violence or drug trafficking. Section 924C of Title 18 prescribes minimum sentences of 5, 7, and 10 years to be added to the sentence provided for the violent or drug trafficking crime. But there is a little statutory challenge in Section 924C. The section begins with the following language, quote, "except to the extent that a greater minimum sentence is otherwise provided by this subsection or by any other provision of law," close quote. Now, pursuant to this except clause, if a greater minimum sentence is otherwise imposed, the additional sentences prescribed by Section 924C do not apply. The statutory question is, what did Congress mean when it said any other provision of law? Suppose, for example, the defendant is convicted of a crime of violence where the sentence for that crime is already more than 5 years. Does the except clause preclude application of the 5-year addition when the defendant was carrying a gun? The plain language would seem to support this result. But for the unanimous Supreme Court in Abbott v. United States, that result was not acceptable. It was almost surely contrary to Congress's intention. Prior to its amendment in 1998, it was perfectly clear that the additional terms prescribed by Section 924C would be imposed even if separate counts of conviction already had sentences exceeding 5 years. Congress amended the section in 1998 to overrule the court's decision in Bailey v. United States on an unrelated issue, and in the course of the amendment added the except clause. The intention of the amendment was to expand the scope of Section 924C's coverage, not narrow it. So the problem for the court was how to give the statutory language an interpretation consistent with that intention. The court's solution was simply to add a common-sense gloss. According to the court, what Congress actually meant to say was that if another provision of the United States Code mandates a punishment for using, carrying, or possessing a firearm in connection with a drug trafficking crime or crime of violence, and that minimum sentence is longer than the punishment applicable under Section 924C, then the longer sentence applies. In short, the phrase any other provision of law was interpreted to mean any other provision of law like this one. A very creative interpretation that probably does accurately reflect Congress's real intention. Our final sentencing case involves the confused set of opinions in Freeman versus United States, where the court had real trouble putting together its decisions. And we'll try to sort it out for you. The Sentencing Reform Act of 1984 allows retroactive amendments to the sentencing guidelines in certain circumstances. And when a retroactive guideline amendment is adopted, Section 3582C of Title 18 permits defendants who are sentenced based on a sentencing range that has subsequently been lowered by the Sentencing Commission to move for a reduced sentence. The issue before the court in Freeman was whether defendants who have entered into a plea agreement that recommends a particular sentence as a condition of the guilty plea are eligible for a reduced sentence pursuant to a retroactive guideline amendment. Needless to say, given the number of convictions taken by plea, the result in this case is pretty important to thousands of prisoners. The court split 4-4 and 1, with Justice Sotomayor casting the key vote and writing the key opinion. So, sort of. Justice Sotomayor agreed with the reasoning, but not the result, in the dissenting opinion issued by Chief Justice Roberts, which was joined by Scalia, Thomas, and Alito. Justice Sotomayor agreed that a sentence pursuant to a plea agreement under Federal Rule of Criminal Procedure 11C1C is based on the plea agreement and not upon the sentencing guidelines. So in a typical case, a change to the guidelines should not be a basis for a sentence reduction under Section 3582C when the sentence is based on the plea. However, the particular plea agreement before the court in Freeman expressly tied its recommended sentence to the guideline sentencing range. According to Justice Sotomayor, when a plea agreement recommended sentence expressly uses a guideline sentencing range to establish the term of imprisonment, then the term of imprisonment is actually based on the guidelines range, and the defendant becomes eligible for a sentence reduction if the guidelines range is subsequently amended with retroactive application. Justice Kennedy penned a plurality opinion which was joined by Ginsburg, Breyer, and Kagan. According to Kennedy, the district court must always employ the sentencing guidelines in deciding upon an appropriate sentence. And that is true even in cases with a recommended sentence that is part of a plea deal. That is why the plea deal sentence is only a recommendation. So for the plurality, the ranges set by the guidelines are always relevant, and a sentence is always based on the guidelines for purposes of Section 3582C, even if the sentence is also based upon a plea agreement under Rule 11. Now the really interesting thing about the 4-1-4 split in this case is that 8 justices agree that the analysis proposed by Justice Sotomayor will, as a practical matter, be unworkable and arbitrary, since it will be very difficult to determine reliably and consistently whether a particular plea agreement actually is based on the guidelines range. My guess is that prosecutors and defense counsel will quickly adapt to Sotomayor's opinion and will quickly figure out what language brings the plea agreement within the guidelines and what language doesn't go far enough. Then it will just be a matter of the relative importance to the prosecution and defense of preserving for the defendant the possibility of a subsequent reduction in sentence based on a retroactively applied reduction in the sentencing guideline. In other words, it will simply become a standard piece of the negotiations leading to a plea. Well, that's it for sentencing. So to continue on to general criminal law, click on the criminal law link in the Supreme Court Review Table of Contents.